Okay, we'll next hear the arguments in the Slaughter case. And Mr. Roehrick, you may proceed.
May it please the court. My name is John Roehrick, and I'm here today with co-counsel Bonnie Hagan to argue the case of Natalie Slaughter, who was formerly a student at Des Moines University in their osteopathic medicine program. The case gets here by reason of a summary judgment that was entered by the Polk County District Court, dismissing Ms. Slaughter's claim for discrimination under the ADAAA for failure to accommodate her disability, which was acute depression. Ms. Slaughter became a student at Des Moines University in the fall of 2014 and began to experience academic difficulties. And on her own, before the university stepped in and started to track her progress because of her failing grades, she sought out services that the university offered, and it offered these services to all students.
Mr. Roehrick, let me just cut to the chase here,
Sure.
at least for me. What kind of accommodations do you think the university should have provided your client?
Should have provided well, they had to first of all sit down and talk with her and address the depression and what she would need to help her in the depression.
But what eventual accommodations do you think the university should have offered her?
Classes, tape, by tape. I realize she did end up doing that, but it was done without permission. Videotape lessons. The ability to take examinations, perhaps of an extended length of period of time. But we don't know, frankly, what all other accommodations could have been granted, because that's which we believe was the interactive process that had to be discussed between her and the the accommodation specialists, such as occurred in the Palmer case, which is the leading case here in Iowa. They had a disability committee that actually sat down with Mr. Palmer and talked about what was needed to accommodate his disability, which in that case, of course, was a physical disability.
When did the interactive process begin in this case?
We believe it should have begun when her doctor, her therapist, first learned of her depression, which would have been in October. Clearly, no later than December, when she disclosed to Dr. Matz, the head of the Academic Progress Committee, that she was suffering from depression.
So to move it back to October, we have to impute the knowledge of the therapist.
Exactly.
Now, on her intake form, didn't it alert her to the fact that she could waive that privilege, and yet she did not? So how do we get around the therapist-patient privilege?
Because the privilege doesn't apply. We never get to the psychotherapist privilege, because the psychotherapist privilege arises only under 622.10, and that is a litigation setting. It arises when there's litigation that it'll involve the confidential communications. That's
What
the
about HIPAA,
critical
though?
words.
I mean, HIPAA prohibits the disclosure of confidential medical information.
It prohibits the disclosure of confidential medical information. Right, the data. But also remember, Judge, that we've ruled here previously in this case, in this court, that Iowa law trumps HIPAA. And that was in the matter of AM, I think it's 856. And you folks ruled that HIPAA was subservient to Chapter 228.
I mean, I don't recall that particular ruling, but what you're saying is if, let's say, I have a child of mine that's attending university or attend here at graduate school, and that person consults a therapist in what they believe to be confidence, that not merely is it okay, but it's the therapist's job to tell the administration that the person is suffering from depression?
I think when you look at the entire process here, where the university was providing the therapist, the therapy, to the student, it was available as a service. The university's own policy permitted the disclosure of general information so that accommodations could be granted, albeit under their policy, accommodation specialist had to hold the information in confidence. But we're talking about imputing the knowledge of the disability to the university, which would trigger the interactive process. And that should have occurred in October or November.
Why didn't she just sign a waiver or ask her therapist to go ahead and work with the faculty or administrators?
The record is unclear on that. It didn't happen until December, when she disclosed to Dr. Matz that she was undergoing depression.
All right, so
And
then
then
what
had
happened then? Just briefly, there's an email,
Correct.
17th, to the chairman of this APC, Academic Progress Committee.
Correct.
And it is explicit about depression, and it's explicit about the kinds of problems. I mean, it's not, it has a fair amount of disclosure about her issues. So at that point, clearly, the university's on notice that A, she has a serious issue with depression, and B, that she's struggling academically. I mean, I guess they knew that anyway. Assuming that's the trigger time for the interactive process, what happened after that?
What factually happened after that? She was placed on academic probation. She was ordered to meet with Dr. John Canby to develop an action plan
Why wasn't that the interactive process?
because it didn't address the disability. Dr. Canby had no knowledge of the disability. He wasn't even aware that, he wasn't even given a copy of the email. In fact, Dr. Canby in his deposition testified that had he known about that disability, he probably would have considered a medical leave as opposed to a dismissal.
Your client have accepted a medical leave?
We don't know. It wasn't offered. Then that would be beyond the record. Our point is,
Can you comment on what impact our decision in Deeds versus City of Marion has on your client's obligation to specifically ask for things? Because she didn't ask for medical leave. She was offered to take the slower track 5th year program, rejected that. What was her obligation to, isn't this interactive process by definition a two-way street? And did she meet her obligation?
it is somewhat of a two-way street. More when you have a physical disability than I think a mental impairment under the Wallstead case and the Fort Wayne, Baltimore versus the Fort Wayne Community School District. I think you get into there's no magic words there. The courts say there's no magic words to bring that about. In the Wallstead case, or Waddle case out of the Northern District, Judge Bennett found that the company knew about her disability. It was known throughout that she had trouble reading, concentrating, everything. So they had an obligation to go forward and set up accommodations, or at least start the process. And that's what we're talking about here, because the failure to accommodate, begin the interactive process, actually is a prima facie evidence of a violation of the ADAAA.
Getting back to the point that I think Justice Wiggins was raising at the very beginning, isn't kind of the bottom line what accommodation would have enabled her potentially to succeed that was a reasonable accommodation that she wasn't offered? And at least on my review of the record, the only one I see that she can really make an argument about that she didn't get was this ability to take elective classes that she was, and it strikes me that on its face the university has a reasonable argument that you shouldn't be taking additional elective classes when you're struggling academically with your core classes. Isn't that a reasonable response?
It may be, but that would also be for the jury. Remember, we're hearing a summary judgment, so all of these matters, which many of which you're raising, were facts that would be for a jury, which Judge Farrell, in his summary judgment, found that we had not carried. And I'm saying, and our position basically is that if you offer the process, which they did, which the university did, they had accommodation specialists in the department called the Center for Academic Success and Achievement, or excellence.
By asking this court to impute that Des Moines University had knowledge of the disability,
Yes.
aren't you conceding a fact then that Des Moines University's actions were not related to her disability? You're asking us to do something to impute that there was knowledge, correct?
Right, which was for the purposes of the commencement of the interactive process.
But if you're asking us to impute that knowledge, aren't you conceding that the university did not know about her disability?
No, they did know about her disability. By the time we got to the summary judgment, Your Honor, they knew about the disability. We're going back in time to when she was a student at the university in October and November.
But hadn't the process already begun by the time she actually stated to someone outside the mental health community, I have a disability? Hadn't the process already begun regarding the concern with her grades and the probationary status?
Only academically, was not addressing her disability. They didn't know about her disability, except through the therapist. And the therapist believed that she could not disclose that because of the privilege, which was not applicable.
Well, that's the key issue, or one of the key issues, and you're suggesting that efforts to address the grade issue, I'll call it just the grade issue, outside the context of knowledge of a disability, is not the kind of interactive process that is required under the statute.
Under the ADAAA?
Yeah.
No, I mean, that's would fall within the academic discretion, but it's when we overlay the disability that we suck in the interactive process procedure.
Must address how that disability could be accommodated.
Yes, under the CFRs, which I set out in the brief. I can find it for you as to the section, Judge, but under the CFRs, it sets out very clearly that you're to sit down, you talk through, you discuss the accommodations that would be needed to address the disability, and then you move on and see if those can be implemented.
All right, so.
That was not done here.
Okay, so then the next question becomes, was the so-called interactive process that specifically focuses on disability, was that triggered by, I think, the December 17th letter? I don't know that there's anything else that would trigger it. I understand you've got the privilege claim, but I want to set that aside. Certainly the December 17th letter, your position is that triggers the interactive process.
That at the latest
Yeah.
triggered the interactive process.
But there's nothing in the letter that says, give me accommodations.
No, because it's our position under the case law and the CFRs that when the employer knows, and I realize I'm jumping to employer, when the employer knows of the disability, then that they should sit down, and I think it's spelled out specifically in a CFR, that they should sit down and work with this interactive process. In fact, there's even in the EEOC manual a section in which a therapist can go to the employer, I'll use that word, and request an accommodation. That is under the AAA. None of that happened here. The therapist didn't do anything because she believed that for whatever reason, or we know the reason, that she believed there was a privilege.
Would it have a chilling effect on students opening up to their mental health counselors if they knew the counselor without their permission might go talk to their faculty about something they've revealed.
We're not talking about details here. No, I don't believe the therapist can go and talk without permission to a faculty or administrator about specific facts. No. Not because under protected mental health information, it's the identity and the diagnosis that is protected mental health information. For me as a therapist to go to the dean and say, we have a student here that I'd like to refer to you, she needs an accommodation because of depression, is not a divulging of any mental health information, and would have triggered the interactive process that the university had built in through their accommodation specialists. I'll cover later further questions next time around.
Mr. Roehrick, thank you. Mr. Baier.
Good morning. May it please the court, counsel. I'm Kelly Baier, and with co-counsel Melissa Carrington, we're representing Des Moines University this morning. And this morning, we asked the court to affirm the district court's judgment that Des Moines University properly and reasonably accommodated Ms. Slaughter, and that the knowledge of the psychologists employed by Des Moines University should not be imputed to the university.
I want to ask you the same question about the other side that I asked Mr. Roehrick. Had you known about the depression, and I think you knew about it by December 17th, what accommodations could or would have you been able to offer this young lady?
Certainly, the university knew in December of the statement of disability from Ms. Slaughter. At that time,
Well, let's assume that. Let's go with that. And what accommodations did you offer, and what accommodations could have you offered?
well, prior to that, Ms. Slaughter was referred to the student counseling services, where she got the one-on-one psychological counseling. Also was referred to CASE, and CASE is the entity at Des Moines University that is organized to deal with accommodations for students.
The discussion with CASE had nothing to do with the interactive process if they didn't know there was a disability. The interactive process requires that you address a specific disability, right?
That's correct.
Okay. Now, as of December 17th, you knew of the disability, I think it's fair to say. And there's not a specific request that, I mean, it doesn't use in-hike word accommodation, but the December 17th memo, as you know, outlines the academic difficulties, depression, and so forth. Now, memo trigger an obligation for an interactive process with Ms. Slaughter.
Well, that certainly triggered an interactive process. We maintain that that process had already started.
Well, except you can't have an interactive process unless you know about the disability.
Well, Your Honor, that's one of the troubling aspects of dealing with disability discrimination. And certainly the Wallstead case that was cited and the Kowski case from the Eighth Circuit talk about when employers, not necessarily educational institutions, but employers may have information such that they should begin the interactive process.
But the interactive process is, I'm going to make a general proposition, and tell me that I'm wrong, of course, but the interactive process under the ADA requires as a predicate knowledge of the disability and an effort to accommodate the disability. Without knowledge of the disability, it's not the interactive process. It might be kind of nice and it might be useful, but it's not the interactive process. Now, do I have it wrong?
Oh, no, I don't think so at all. I think one of the difficulties, though, is the wide range of disabilities, and certainly a mental health disability. And without the student, in this case, identifying that she has that disability.
By the 17th, she did.
Right.
Before then, I want to set that aside. So as of the 17th, she identified the disability. And my understanding from the record, you correct me, my understanding of the record is what happened after that included a meeting with the associate dean and so forth, who had no knowledge of the disability at all, and that after December 17th, there really wasn't an interactive process directed toward her disability.
Well, I would disagree with that, when Dr. Matz received the email, that was prior to the Academic Progress Committee recommendation. Dr. Matz was chair of the committee. Dr. Matz sent a letter after that email and met with Ms. Slaughter to walk through the recommendations of the Academic Progress Committee. So I think that is at least a beginning of an interactive process. And Dr. Matz talked with her about what the committee recommended, that she was on probation, which meant that she could not do extracurricular activities, that she needed to drop electives, drop outside employment, offered her the extended Pathways to Success program, which would have allowed her to take 5 years to complete her program instead of 4.
When did these discussions happen, approximately?
That would have been after December 17. That was in the APC committee letter to her. That was one of the recommendations. She also spoke with her faculty advisor, Shelley Oren, right after the committee meeting itself about the Extended Pathways to Success program. So she had several opportunities to discuss that, and that was offered as an accommodation.
What about the medical leave? That was really never offered, was it?
It was certainly always available. Was not suggested by either Ms. Slaughter or by Des Moines University. And in a way, you have to question whether that would have worked, because that would have also delayed her graduation, which was one of her concerns, that going to the Extended Pathways to Success would be a 5-year program. If she had gone on a medical leave, she probably would have had a 5-year program as well.
Respond to her argument that, you know, if I'd been able to continue taking electives, I would have had more self-confidence, and that would have actually helped me, and that would have been a reasonable accommodation to give me an exception from the normal academic probation rules. At least that's a jury issue. How do you respond to that?
2 ways. One, I think it is a common sense approach taken by the university that rather than spending time on electives, a student who is having difficulties should concentrate and spend their time on the core courses. I think, though, the second thing is the only evidence we have is Ms. Slaughter's own belief. She did not offer an expert saying electives would help her, did not offer any other evidence than her belief. So I would maintain she did not raise a factual issue about whether electives would be a reasonable accommodation for her.
Are there recognized accommodations that specifically address different forms of depression?
I think one of the, again, challenges is every case is different, and that's why this court requires an individualized assessment. Some of the things that may work when someone is suffering from depression is an extension of time in which to complete their academic career. And that's the Extended Pathways to Success that Ms. Slaughter turned down.
But because there's different forms of depression, does that make it into a jury question when there's other things that might have been able to be done for her?
Well, there again, I think if Ms. Slaughter had raised other accommodations that were not offered to her, really, as recognized by the court, the only accommodation that she'd requested that she did not receive was that she be allowed to continue to take elective classes. That was not permitted. She asked that she not be enrolled in the Extended Pathways to Success program, and the university said, that's your choice. She asked that she be allowed to continue to see classes or watch classes online rather than attend in person, and the university said, that's your choice, you can do that.
The district court find that there was no interactive process? Did I misread that? I mean, it seems to me, I read the district court order as saying that DMU did not engage in interactive process, partly because Slaughter didn't demand any specific accommodation. Have I missed that?
Well, I did not read the decision that way, and I think that if we take your December 17 date as acting on the interactive process. That after that, Dr. Matz met individually with Ms. Slaughter to go through with her the Academic Progress Committee recommendations.
But the Academic Progress Committee recommendation was made on the 16th, prior to knowing her disability. So you're discussing something that has nothing to do with the disability because the disability wasn't known.
But in that meeting that Dr. Matz had with Ms. Slaughter after the decision was made, where he explained what the decision was, one of the accommodations recommended was the extended pathways to success, where that was discussed and certainly offered, and where Ms. Slaughter said, you know, I don't think that will work for me. I think going to fifth year would be harder on me than going on the 4-year plan. So there was a discussion of accommodations there.
Did she ask for more time to do final exams?
No, Your Honor, there's nothing in the record of that nature.
Should that have been offered to her?
I think, again, and it goes a little bit to the Chief Justice's question, you're trying to find out what will work for the individual. And when the individual hasn't requested a particular accommodation, it is difficult for the educational institution or the employer to guess. And I think that's one thing that you reckon.
But on depression, go back what the chief is suggesting. Depression is unfortunately somewhat common. And certainly an academic institution like DMU has some familiarity with it, and there's packages of potential accommodations that are available. In fact, the case law, as you rightly state, suggests that mental health can raise some difficult issues because the person suffering from depression cannot always articulate. You don't exactly know what's going on, and the case law does stand for that proposition. Maybe that cuts in your favor, but surely you can expect DMU to be actively involved in the interactive process and not wait for the person suffering from depression to kind of hit the right buttons.
Well, and I think they were actively involved. Not only did Dr. Matz specifically meet with her on a one-on-one, Dr. Canby met with her, and even though Dr. Canby had not been informed of the disability, the purpose of his meeting was at the recommendation of the Academic Progress Committee, which had been informed of
It's hard
her.
for me to see how.
That's one of my problems with your argument. It strikes me that all of the measures taken by your client in response to Ms. Slaughter's problems would have been offered to anybody in trouble with grades. And so, and if I'm wrong, tell me, but it strikes me that the university's response was all about your grades are bad and you've got to get that taken care of. There was nothing that I recall seeing in the record that the university did or recommended that responded specifically to Ms. Slaughter's claim of disability, namely depression, that the university wouldn't have done for any person in grade trouble.
And I think you're correct that the things that were offered to Ms. Slaughter could be offered to other students with or without a disability. But that doesn't take away from those particular accommodations also being helpful to Ms. Slaughter. When Dr. Matz sat down with her and drew anatomical pictures and showed her how to label those, that was specific to her. When Dr. Canby sat down with her and went through a program for her success, that was specific to her. The fact that these accommodations might be available to others does not mean that you can't use them for someone with a disability.
Does the record show that they sat down with her mental health provider to see what kind of accommodations would have helped her get through the semester after December 17th?
They did not sit down with the mental health provider, with Dr. Sanders. There was never a release given.
There was never a discussion from Dr. Martz or Dr. Oren, and there's one other person, that, in order to figure out what we can do for you, we need to talk to your mental health provider, and there is never anything from this young lady saying, no, you can't.
And again, the law prohibits that psychologist from disclosing that information without a release from Ms. Slaughter. And Ms. Slaughter did not provide that release. Now, certainly she could have done that, but she did not. And for Des Moines, first, I'm not sure that Des Moines University knew that Ms. Slaughter was actually seeing Dr. Sanders, knew that she was going to the student counseling, but probably did not have information she was actually
But in
being
this
treated.
interactive process, don't they have an obligation to find that out and to see how they accommodate her based on her depression? And all they were offering her, as Justice Heck said, is what they offer any other student, and it was all formulated before they knew she was even depressed.
Well, I think, no, that they do not have that obligation, that to ask that question is inappropriate and probing into the private mental health information of the student. The student is in control of that information, and certainly the student can provide that, and did not in this case. Thank you very much.
Mr. Baier, thank you as well. Mr. Roehrick, you may present your rebuttal.
Thank you. May it please the court. Just want to point out, this is a summary judgment, so we're into whether the court made findings of fact as opposed to basically letting a jury make the decisions, many of which would have involved exactly the questions that you're
What obligation did
Here.
your client have to offer the assistance of her healthcare provider in developing accommodations for her to complete her courses?
I think she talked to her therapist. Okay, that we know, weekly. She disclosed in a letter after talking with her faculty advisor, Shelley Oren. She had been meeting with Shelley Oren all semester.
But how does the university provide specific accommodations to her for her specific disability if they can't get a handle on what it would take to do it by talking to her healthcare provider?
Well, I think they can.
But how can they do that if she doesn't release the information?
Under their own rules. And that was Exhibit 54 in there, in which and this had just been changed in August of that year. This is the rule of the retention of student documents. And in it, the university said general information about a student's disability, however, may be shared with other DMU officials or in limited circumstances with third parties on a need-to-know basis. So they were aware, and let's go to December. Let's go to December
Is that
17th.
knowledge of disability from professor to professor, or knowledge of disability from a separate wing of the university that provides health care not only to students, but the general public?
It goes to the entire university because Des Moines University is a holistic institution. It furnishes not only educational services, it furnishes counseling services because it recognizes that there are students who are going to have disabilities, mental health issues. And it is also provided accommodation specialists, 2 of them, that were within the Department of Case. Des Moines University holds itself out as a holistic institution.
All right, but getting back to that regulation and following up on Justice Wiggins' question, all right, that says that once there's a disability disclosed, that information can be passed along around the
Correct.
university on a need-to-know basis. But the question that I thought was on the table was, on what basis would without your client's initial waiver of the privilege, on what basis would DMU have been able to contact the therapist and discuss specific accommodations with the therapist?
before or after December? Before December, it was our position that that knowledge of the disability was imputed.
Let's say we
After
disagree
December-
with that argument.
Okay.
On the imputation, that we
All right.
disagree with that. We think HIPAA applies. Then say that we disagree, then what's your basis for saying that the university should have contacted the therapist and talked about specific accommodation?
Because on December 17th, Dr. Matz received the email. He also, by that time, he knew she was in therapy. He could have gone to the therapist. He could have gone to Shelley Oren, her faculty advisor.
But Counsel, is that a question of law, whether Dr. Matz could go to Dr. Sanders, the therapist, and talk to her about treatment and accommodations without Ms. Slaughter's waiver? Isn't that a question of law?
Well, it's a question of law if you're going to interpret the university's policy. But at that point in time, she was asking for an accommodation. I hearken then to Justice Heck's decision in Palmer, in which he says that they have to start the objective process, and Palmer lays out specifically what is needed to be done. Those are jury questions then. And here we have basically Judge Farrell, who basically says, don't have to go down the interactive process.
I mean, but still, reasonable accommodation, I'm sorry, I'll stop. Your red light's on. Thank you.
Well, I'll answer the question of Judge Gaty.
You may sum up, counsel.
Okay. Our position basically is that Judge Farrell entered into the realm of fact finder in his decision and overruling that the jury questions were generated on the evidence as to whether there was a disability, the accommodations, et cetera. Coupled with that, of course, is the issue of the privilege, because if it's remanded and goes back, we're going to meet the same issue at the time of trial. So we submit that the trial court erred in granting summary judgment, and that we should be granted, it should be reversed and sent back for trial. Thank you.
Mr. Roehrick, thank you as well. And Mr. Baier, thank you again. The case of Slaughter versus Des Moines University is now then submitted to the court, and the bailiff may adjourn.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.